now in session. Please be seated.
All right, thank you everyone for your patience. We will resume. Can you hear us, Judge Holloway?
Yes, I can hear you.
Oh, good.
Sorry, everything was ready to go at 8:30. I've been down here since 7:30. And then at 9:30 when we switched over, it all shut down.
It's all right. We're back, so we appreciate it. We're back in session, and thank you all for being here today. This is day 2 of our first docket of the year for January 10th today. We've got a couple of cases on the docket. We've all kind of been introduced electronically already to Judge Holloway, so I'll introduce our panel. To my left is Judge Tim Easter from Williamson County, and then on our screen is Judge Bobby Holloway from Murray County, and he is participating remotely because he's been a little under the weather, and we appreciate him not bringing his germs to Nashville. We made a little bit of fun of him yesterday and said he looked a little bit like the Wizard of Oz, but the real wizard back behind the curtain is Nick Morgan and Barbara Peck, and we thank the AOC for bringing this technology to us. It usually works better when we don't mess with it, but we've got it all figured out now. So thank you for that. Any preliminary matters this morning?
No, Your Honor.
All right, now I think we're ready to call the first case, and I believe we've got a brand new attorney. I understood, is it on this case General Ball wanted to introduce?
Yes, Your Honor.
Go ahead.
May it please the court, Your Honors, Ben Ball have stated, this is Brooke Huppenthal. This is Brooke's first argument. She has been with our office for a year and a half. Okay. You've seen her name in briefs.
Yes.
She's filed several for argument, but this is the first one that's made it here, and I'm thrilled to introduce her to you.
Very good. We're happy to have you here this morning. Thank you.
If she would just speak loudly into the microphone, because I had a hard time hearing General Ball.
Okay, will do.
State of Tennessee versus Eric Tyre Patton.
And if you see us looking to the side, we've got a small screen of Judge Holloway back here, so we try to look for cues to see if he can hear us and see us. So do speak loudly into that microphone for all of our benefit, especially his. And as you know, everyone has 20 minutes. If you'd like to reserve any time for rebuttal, please let me know.
Good morning, Your Honors. Drew Justice from Murfreesboro for the appellant Eric Patton. I'll reserve 4 minutes.
Thank you.
Certiorari and reversal are warranted here because the lower court acted illegally and or arbitrarily, and because there's no other plain, speedy, and adequate remedy. The court acted illegally or arbitrarily in multiple ways, but probably the biggest way was that it refused to apply the statutory presumption under modern drug law that the school zone enhancement should not apply to Mr. Patton, and therefore by failing to apply that presumption, the court falsely said that Mr. Patton had not adequately proven that he would get a lighter sentence under modern law, when in reality he had. That error then infected the rest of the court's ruling as well. It infected the interests of justice, balancing analysis, because the lower court could not possibly compare an older, more harsh sentence to a newer, more fair and lenient sentence if it would not even acknowledge the existence of the newer, fairer sentence as a possibility. And then in addition, the court acted arbitrarily by botching the factors that it was tasked to consider further when judging the interests of justice. I think it's basically undisputed at this point that there is no other adequate remedy or any remedy at all other than certiorari, so that step should be satisfied under Rule of Appellate Procedure 3, and under all the other appellate rules, there's just no other appeal given for this type of case. And so there is no appeal, but this court does have certiorari power both under the statutes as well as the Tennessee Constitution, and in fact even predating the Tennessee Constitution under the common law, the appellate courts would have had certiorari power. So anyway, I don't think that lack of remedy is really disputed, so I'm going to focus on the illegal nature of the lower ruling. The first way that the court acted illegally is it disregarded the statutory presumption and therefore said that Mr. Patton had not proven that he would get a lighter sentence under modern law. He in fact did prove it because there is a rebuttable presumption that a defendant is not required to serve at least the minimum sentence for the defendant's appropriate range of sentence. This is from 39-17-432C under the modern law. The rebuttable presumption is overcome if the court finds that the defendant's conduct exposed vulnerable persons to the distractions and dangers that are incident to the occurrences of illegal drug activity. Here there were no findings to that effect about any vulnerable persons by the sentencing judge. There were no findings about it by the motion judge at the motion hearing below.
Let me stop. It's the defendant's burden to prove that on resentencing, correct?
It's the defendant's burden to prove that this presumption applies in his favor. And if the state wants to rebut the presumption, then the state can do that. But by proving that there were no findings by the sentencing judge, no findings by the motion judge, no findings, or no evidence of it in the trial, no argument about it even by the state at the trial level, no argument about it by the state even at this level, I submit that we've done all we can.
Did you present evidence at the hearing? Was there any evidence presented at the hearing?
We asked the judge to take judicial notice of the record, so that's the only evidence that was presented.
Judicial notice of the previous sentencing hearing?
Of the entire, yes.
Of all of it?
Yes, sir.
Including, I mean, we've reviewed this case on direct appeal.
Yes, sir.
And I can't recall, was sentencing an issue on direct appeal?
It was not.
Okay.
And so the point is, if it was, there was no dispute. No one even argued that any children or any kind of vulnerable persons were affected by this. Instead,
But you didn't have to argue that under the prior law.
What I'm saying is that even at this motion hearing, no one even argues that. No one argued it at the motion hearing. I don't think the state's even arguing that today. It's undisputed that no children were impacted. It's undisputed that no one has ever made any finding to the contrary. And so it's clear that this rebuttable presumption applies, and for the judge to say that we have to prove something more than that is just refusing to apply a presumption and refusing to apply the law. The only thing that the state did argue for at the lower level was at the motion hearing was it made the false and foolish argument that children don't have to be impacted, and that they said just being within 500 feet of a preschool and or a private school, well, I think it's undisputed that it was more than 500 feet from the private school, but being within 500 feet of a preschool, they said that was enough to get the parole ban. And that's clearly wrong. They're just making like I said, a false and foolish argument. And as is so often the case in the trial courts of Tennessee, when the DA stands up there and makes a false and foolish argument, here the judge was not willing to call them out on it, and instead he seems to have just bought it. And so, again, because that presumption clearly should have applied, and because the whole denial of the motion was based off the fact that it supposedly didn't apply, or we had to prove something beyond that, the judge violated the law, he acted illegally, and acted arbitrarily. I will say the state's brief is sort of confusing. They basically try to have it both ways. On page 20, they seem to say that the judge's ruling on that was correct, but they don't articulate any reasoning for why it would be correct. But then on pages 21 to 22, they seem to concede that it wasn't correct. But I would submit the concession on pages 21 to 22 is the right concession. The judge's ruling below was not correct on that. On pages 21 to 22, they say, well, he was, even if he was wrong on that, he could still deny the motion for no reason at all. I submit that they're misstating the law on that. The law does say on 39-17-432H4, it says this subsection H does not require a court to reduce any sentence pursuant to this section. That's not saying that the judge can just act illegally or arbitrarily, though. What that's saying is that the judge has a discretion, and he's got wide discretion about what he can do, but he doesn't have unbridled discretion. He can't just say, well, I don't like you because you're black, or I don't like you because you got blue eyes, or I don't like you for whatever reason, and therefore I'm going to deny your sentence. And so he still has to act, he cannot act arbitrarily. He has to act within the law.
But the statute also says that resentencing the defendant to a shorter period of confinement for the offense would not reduce the defendant's overall sentence or lead to an earlier release, or oh, no, that's not the part I was looking at, I'm sorry. It looks like there's an alternative where the court may consider those specific factors for interest of justice, but if the court finds it's not in the interest of justice, then the court can not resentence.
That's what I was about to get to next. The problem is that I'd say the biggest problem here is that the judge's initial error infected the whole analysis, including the interest of justice. And so the interest of justice ruling was arbitrary and illegal as well. A judge cannot judge between two different sentences and decide which one is more fair and just if he's unwilling to acknowledge that under new law there would be a second sentence. You can't compare one sentence against itself. That's not a comparison. If you just say, well, he was eligible for the parole ban under the old law, and he's also eligible for the parole ban under the new law, what's to compare? And so the problem is there's no comparison if there's only one available sentence. These sentences...
Mr. Justice?
Yes, sir.
Can you hear me okay? Let me go back to H1 that you mentioned just a moment ago. And there's a sentence in there that reads, the defendant shall bear the burden of proof to show that the defendant would be sentenced to a shorter period of confinement under this section if the defendant's offense had occurred on or after September 1, 2020. All right, so the defendant in this case was charged with a school zone violation. His class of offense was enhanced one level. It made it an A. Is that correct?
Yes, sir.
Originally.
Well, no, I think it was an A already.
Okay, already. And so the judge in this case is dealing with an A felony. So you have no problem about the classification that the judge did, right?
Correct.
Okay. And the sentence for an A felony, and I don't have that pulled up, I've got it here somewhere, but would be 15 years minimum, is that correct?
In this case, I think 25 to 40.
Okay, 25.
Because he was
ranged
range.
too.
And so,
Yes, sir.
so you agree that the judge had the discretion on resentencing to sentence the defendant to 25 years?
Yes, Your Honor, yes.
Okay. And would you also agree that the sentence that the judge could impose would not necessarily be less than the sentence he originally received?
What I would agree with is that the sentence would have to be 25 years again, and it is 25 plus 25 for a total of 50 because it's two counts. But we're not claiming that the term of years would be shorter, but it would have been an effectively shorter sentence due to the fact that he would be eligible for good time, behavior time, and almost certainly parole.
And that has to do with the fact that the original mandatory minimum sentence language of the statute before the last amendments.
But under his original sentence, he's got a sentence of 50 years day for day. Under modern law, he would get 50 years with parole eligibility at 35% minus any good time and any behavioral credits.
They're getting that that modern law from where?
The modern law meaning the September 2020 amendment, where they said that the rebuttable presumption is that you are parole eligible. And so if his crime were committed and if he were sentenced under, after September of 2020, then he would get eligibility for parole at 35% minus any good time and minus any behavioral time. And so even if they denied him parole the entire time, he would still get any behavioral credits and any good time as he's serving out his 50-year sentence. So one way or another, he would be shorter. And, you know, they usually parole drug people anyway, so he would probably get parole at the 35% mark, but even if he didn't, his sentence would be sure to be shorter under the modern law that was passed in September 2020.
All right, let me ask you, again, this statute to me is very confusing, but let's go back to the minimum sentence, which have changed the language, I understand. And this rebuttable presumption. All right, let's assume that you met the rebuttable presumption, even though the court didn't find that. So even if he's presumed to be eligible, that just then takes you to the interest of justice factors. Is that correct?
Yes, Your Honor.
And did the judge go through any of the H1 factors that are listed in the statute?
He purported to. I submit he basically did not. At least he didn't go through them completely.
All right. Well, if he went through the factors sufficiently, and I'm not saying he did, I'm just speculating now or hypothetical. If he went through the factors adequately, hypothetically, would it make any difference whether or not he found the presumption was met or not met?
I submit that does make a huge difference because you cannot compare a sentence under the new law, a more lenient sentence under the new law versus a sentence under the old law that's harsher, if you're unwilling to admit that the new law would in fact give you a more lenient sentence. You cannot. How can you say which one is more just if they're both the same? And so that error infects the whole analysis from the start. In addition to that, the court just misapplied the factors. The court is supposed to consider, among other things, whether a plea deal was entered, for example. He's supposed to consider the facts surrounding the offense, including but not limited to whether a plea deal was entered. Here there was no plea deal, but the judge did not consider that. Whether there's a plea deal ought to be one of the most, probably the most important factor of all, because if there's a plea deal, then the state legally gets a contractual interest in maintaining that prior sentence.
Did the legislature say that, or did Drew Justice say that?
The legislature required that they're supposed to consider whether there's a plea deal, and I'm submitting that in most cases ought to be the most important, because again, that's what gives the state a contractual interest in maintaining the plea. In some cases, I had one of these cases where someone was charged with 5 different cases. The state outright dismissed 3 of them, made them plead guilty to one school zone offense and then a one non-school zone offense in the other. And then the court ultimately denied the motion for resentencing because he said the state can't bring back those old charges that they dismissed. They have the contract. So the judge denied that motion. We didn't even challenge that one any further. And I just submit that should be one of the main factors. But here the judge did not consider it at all. He claimed that Mr. Patton has a history of violence based on 2 misdemeanor assaults committed 27 years ago when he was 19. Anyway, my time's about up, so I'll come back for a rebuttal unless there are any more questions.
Let me just ask you this. I'm sort of struggling with one of the factors, as I understand it, that the resentencing court can consider is the defendant's behavior while incarcerated.
Yes, Your Honor.
And you gave him the trial judge nothing on that, correct?
The state, I think, introduced something showing that he had been caught with a cell phone at one point, and the judge said that he did not consider that a big deal. So basically, the disciplinary was not weighed against him, as far as the judge said.
Thank you.
Okay. Thank you. General?
Good morning, Your Honors.
morning, yeah.
All right,
Very
can
good,
hear
thank
me?
you.
Okay, perfect. May it please the court, Brooke Huppenthal on behalf of the state. This court should deny the defendant's petition and affirm the trial court's judgments to deny his motion for resentencing. The decision was authorized by statute. Under subsection 4, trial courts are not required to resentence defendants under the most recent amendment to the Drug-Free School Zone Act. First, I would like to note that the defendant correctly stated that he did have 18 convictions, not nearly 20, but that has no consequence in this case because, as I mentioned, trial courts are not required to resentence defendants.
I'm interested in hearing from the state on whether you think he's properly here under a writ of cert. He seemed to say, if I heard him correctly, the state kind of agrees that's the proper way to get it here. Do you agree with that?
The court
You
should,
understand my question?
I believe so. It would be the only way in this instance to challenge the trial court's decision. There is no right of appeal.
Right.
The court held that last year.
Mm-hmm.
However, in this particular case, the trial court abided by the statute, followed proper procedure, held a hearing, and followed the necessary procedure. First, it held that the defendant would not be entitled to a shorter sentence, or he wouldn't be sentenced to a lesser sentence under the act, and he wouldn't be entitled to resentencing because of the interests of justice. This case, I do want to note, it's not an instance where the defendant simply was just pulled over and happened to be in a school zone with drugs. This was a very large-scale operation involving significant quantities of heroin and cocaine, and it involved sourcing from out of state. There were 21 co-defendants involved, and the proof showed at trial that the TBI had attached a video camera to a telephone pole just outside the defendant's tire shop, which was 25 feet from a preschool. And in that tire shop, one co-defendant had testified that there were heroin deals happening at that shop. And in terms of the lesser sentence, it's correct that the enhancement wouldn't apply necessarily. There is a rebuttable presumption. In this case, he would have violated the act under it as amended because there was an offense that occurred within 500 feet of a school zone. And the rebuttable presumption can be overcome with the finding, the vulnerable victim finding. And the judge did not make a specific finding in this case. However, there was proof that there were heroin deals happening within mere feet of a preschool. And I believe it was in Watson in September of last year that this court held that the vulnerable victim finding needs to be more than the drug deals happened in a school zone. But this was within mere feet within a preschool. But all that to say, subsection H4 does not require trial courts to resentence defendants. And it's only one portion of the statute that the trial court needs to consider.
Well, do you think that subsection relieves the trial court from making any of these other analyses under the statute?
No. I mean, so the trial court does need to have a hearing, and there needs to be at least first a finding that the sentence would not be shorter under the amended act.
And was that finding made in this case?
The trial court found, yes, that it would have not been lesser, and that's because either way, the defendant would have violated the act as amended because the offense occurred within the 500 feet, and trial courts, in that instance, a trial court could have sentenced him to serve 100%. And while there wasn't that rebuttable presumption finding in this case, it all circles back to the fact that the trial court was not required to resentence, and it also made the specific findings that the interests of justice weighed against his resentencing. as I mentioned earlier, the facts were significant in this case, and that is one, in the specific findings in terms of the interests of justice are discretionary. It says the court may consider these factors. And at the end, I believe it's section H1D, it says any other factors the court deems relevant. So they're not required in this instance. But the court did consider each, and it mentioned each in its findings. It mentioned the criminal record. It mentioned that the defendant did have prior drug offenses and that it occurred over a lengthy period of time. The judge mentioned that the defendant's behavior while incarcerated wasn't significant enough to weigh against the interests of justice. And finally, it found that the circumstances of the offense were very significant in this case. It did note, the judge did note that there was no plea deal in this case. However, that's not a required finding. And ultimately, the trial court concluded that the interests of justice did weigh against resentencing the defendant in this instance.
So, I mean, we're all still working through application of this new statute. I think that's obvious. In looking at subsection H1, I mean, it's somewhat of a two-part. Defendant has the burden of proving that he would be sentenced to a shorter period of confinement. And then it says the court shall not resentence if the new sentence would be greater, or if the court finds that resentencing would not be in the interest of justice. I think the appellant is arguing that the trial court has to do both of those analyses. And is that the state's position, that the trial court has to make the finding about whether the sentence would be shorter, or can it just jump to, in any event, it's not going to be in the interest of justice, and here's why?
So the trial court would not be required to make both of those findings. I think it would be preferred, but however, they're not both required in this case. And ultimately comes down to the fact that we are here on writ of cert, and the trial court's decision was authorized by statute. It was not illegal, it was not arbitrary, because it was authorized not to resentence him. And briefly, I did want to mention the range eligibility. He was range 2. He was entitled to, or under range 2, it would be 35% of his sentence. And in that instance, he did violate the statute, or he would have violated it as amended, and a trial court would have been entitled to sentence him to the full amount.
Entitled but not required.
Yes,
Is
that's
that a
correct.
distinction we need to look at?
I think that goes towards the rebuttable presumption. I think it would be helpful to flesh out. I think it is briefly mentioned in the Watson case, the discussion regarding percent eligibility. However, ultimately it comes back to the fact that the trial court was not required to resentence him. And unless this court has any further questions.
Does the state take the position that in these resentencing matters, a vice type standard applies? In other words, if the court makes the appropriate finding, it comes up with a presumption of reasonableness.
So in these cases, the permissible, the appropriate way to challenge a trial court's decision to resentence would be under the writ of certiorari. And so in terms of challenging that specific sentence, I think it wouldn't be a bystander. It would be, at least in terms of the actual resentencing decision itself, not if the defendant is initially being sentenced under the act, if that makes sense. We're talking about post 2020 versus pre 2020. So it would be pre 2020 would be under writ of cert standard, because the trial court would be looking at whether or not the defendant should be resentenced. And post 2020, yes, I would believe, and I would be happy to offer supplemental briefing in that instance, because I haven't briefed that in this case.
The state's not taking the position that if the court fails to do the things that the court can do under H1, that then the court can act arbitrarily and capriciously and just dismiss a resentencing motion, is it?
Well, no, a trial court would not be entitled to act arbitrarily or illegally. There are some specific findings that a trial court does need to make, and the statute does outline those. And if the trial court does not make the specific findings as required by the act itself, then yes, it would be an arbitrary decision. That did not happen in this case. The trial court walked through the proper procedure. There was a hearing. The trial court made findings about whether or not the defendant would receive a lesser sentence, and it determines that the interests of justice weighed against resentencing. If a trial court does not make each of those findings, it would go towards this court's decision whether or not to grant a defendant relief, because it would go towards whether or not the trial court made an arbitrary decision. And unless there are further questions,
Any questions?
the state relies on its brief for the remainder issues and asks that this court deny the defendant's petition and affirm the trial court's judgments. Thank you.
Thank you. Mr. Justice, I believe you have your 4 minutes.
The state has said that the court was entitled but not required to bar Mr. Patton from parole. I submit that the court was not entitled to bar him from parole, because to do that, there'd have to be a finding that children were impacted by or endangered by this crime, and there'd have to be some evidence to support that finding. And there is no such evidence anywhere in the record of this proceeding or the prior proceeding that the courts have taken judicial notice of, that the lower court took judicial notice of. So there's nothing to support barring him from parole.
Have we seen many cases on that to know what that type of evidence looks like? I mean, obviously common sense can apply there, but we heard from the state that there was evidence that, large heroin transactions were occurring in a tire shop during various hours of the day within the required distance from a school.
I mean, you would need to. I'm not aware of a specific case that talks about those findings, but I'm just saying there was no testimony whatsoever about any children. There was just nothing other than the fact that it's within a certain distance from the school or from the preschool. And so the whole purpose of this new law, the change in 2020, was to say just being close to a school or a preschool is not enough. And so for the state to then argue at the motion hearing below that that was enough, they were just blatantly misstating the law. The judge said, in applying the factors, the judge said that he was, again, the disciplinary was not held against him. The plea deals were never even considered. I submit the circumstances surrounding the offense in general were not considered, because instead of the circumstances surrounding the offense, including but not limited to plea deals, which is the language the statute says, the judge only said he was considering the facts of the offense, and that was his exact language. The facts of the offense are that it's a Class A felony. And so,
Are you saying that there's a difference between the judge saying considering the facts of the offense and the circumstances of the offense?
I'm absolutely saying that, because when it specifically talks about plea deals, that's a circumstance surrounding the offense, meaning the case as a whole. And so I'm not sure that the facts of the offense should even be relevant at all, but if they are relevant, they're not, there shouldn't be the whole factor. If they were the whole factor, the legislature would have said, you know, we're not allowing resentencing, or the judge should weigh it against any resentencing if the defendant was convicted of a Class A felony.
So you're arguing that the language that says the circumstances surrounding the offense shouldn't include the facts?
I am basically saying that, yes. Or if they should not, or if they do include the facts at all, that should only be a part of it. And you're supposed to go beyond the facts, including plea deals.
You keep saying you're supposed to, or the trial court's supposed to. Is it your position that the trial court is supposed to consider all of those? That he has to, that it's mandatory that he or she consider the criminal record, behavior, incarceration, circumstances, all of them?
I guess I'm saying that if he's going to consider that factor at all, he needs to at least consider the whole factor, which specifically talks about plea deals, and not just say, this was a Class A felony under the facts of the offense, so therefore I'm going to deny parole on that basis.
Doesn't H1 say the court may consider the following factors?
Yes, but I'm saying here he's picking a factor and just distorting it instead of even applying that factor. And so he's basically making up his own factor, and I just submit that was an arbitrary ruling. If the legislature wanted to ban Class A felons from this motion, it would have said so. But just to conclude, I mean, imagine you've been sentenced to 50 years day for day under this extremely harsh old law. Legislature then passes a law that says if you had committed your crime after September 2020, you would have gotten 50 years at 35%. You would have been eligible for good time, behavioral time. Then you go into your motion hearing and the judge is confused. He thinks that the new law doesn't apply to you when it very plainly would. And so he doesn't even, he can't weigh that new sentence versus the old sentence because he's not even looking at two different sentences. So you never had a chance. And then he botches the factors. He holds against you these two assaults. We just submit that the judge has acted illegally or arbitrarily here. I ask that the court reverse the judgment below and either order a sentence of 50 years at 35% or remand for reconsideration under the proper legal principles.
Thank you both for your arguments and your briefs, and we will take the matter under advisement. If you'll call the next case, please.